Welcome to the Autism in Black podcast, where we focus on all things autism and the Black parent experience. Our goal is to always educate, support, and empower parents to advocate for not only their children, but themselves. Hello, and welcome to the Autism in Black podcast. I'm Maria Davis-Pierre, a licensed mental health counselor in the state of Florida and America's #1 autism advocate for Black parents. I am the founder and CEO of Autism in Black, Inc., where we aim to include the excluded. Today, we have Sandy Boisrond on the show. She is a trust and estates attorney and primarily handles estate planning, guardianship, and probate matters. She serves clients throughout the state of Florida and is the co-founder of Spectrum Law Firm in Miami. Her services are particularly geared towards supporting special needs families to help them create long-term plans, as she is the aunt of a 13-year-old who has autism. Prior to the practice of law, she served the Broward County Public Schools for about 8 years as a middle school science teacher and elementary school substitute teacher. She has also served on the Haitian and Caribbean community as a nonprofit community liaison and program coordinator. I'm really excited at having Sandy on the show today to talk to us about guardianship, estate planning, and trust planning for our children. So enjoy today's show. Hi, and welcome to another episode of the Autism in Black podcast. Today we have a very special guest who is going to educate us on estate planning, which is so important. Please help me in welcoming Sandy Boisrond, who is going to be educating us on estate planning. Thank you, Sandy, for being here today.
Thank you so much for having me. Good evening, everyone.
Now, I have read your very impressive bio, but can you tell us more about yourself?
Sure. So I like to do things in a lot of threes, and you'll notice that as we talk today. I am a self-proclaimed auntie for autism. I have a 13-year-old nephew who is on the spectrum, who dominates quite a bit of my time outside of my work. I am what I would describe as a legal agitator. So not only am I an attorney, but I'm an individual who sees the practice of law in a very different way. And I'm a creator. I do a lot of different programming and activities, either through my firm or individually. So you'll find that as you look through any of my information that I have my hands in a lot of different things.
Yes, and I noticed that you were a teacher prior to being a lawyer. So how do we get from teacher to lawyer?
So I'll even take it a step further. Before that, I worked for a nonprofit and I was doing community outreach, and I worked a lot with the refugee population. So I am an educator at heart. Even as a little kid, I remember doing, playing school and things of that sort. So it wasn't a career path that I chose. It was something that kind of has always been in my life. Even now, as I think about my legal practice, it's the same. So education just came as a natural progression. I worked a lot with families. I was doing community education and outreach. I was doing a lot of workshops and programs and working with a lot of different nonprofits. So that was just like the next step, working with the kids and their parents.
Now, as we know in the Black community, when we begin to talk about estate planning and things of that nature, we get a little tense. We don't like to talk about it. We don't like to acknowledge it at all.
Right.
I want to make sure we are, letting parents know that, one, this is a conversation that needs to be had, because more than likely we will pass before our children. So we need to be making sure that they're taken care of as best way possible. So what should parents know about planning for the unexpected?
So I'm going to say something that sounds a little bit circular, but makes sense when it comes to this type of topic. You can't prepare if you don't plan, and you can't plan if you don't prepare. So when it comes to the unexpected, there's no announcement of when something is going to happen in your life. So all you can really do is think about things in terms of the worst case scenario and the best case scenario. And with that, I like to tell folks, you want to have a checklist in your mind of what happens if. And if you can go through that checklist of what if or what happens if, then you can really touch on all of the different possibilities and prepare your family for those types of things.
I love that. So when we're thinking about this checklist, should it be things like, if I'm in a coma, then what happens? Or,
Yes.
Okay. So, these
So you start with the coma conversation and you go to simple things like, what happens if I'm unable to pick up my children from school?
Okay.
What happens if someone else has to take care of my child who has autism overnight for a few days? What happens if both my husband and I are unable to care for our children for a month? It kind of goes through a series of the worst case scenario through the best case scenario. So I like to describe it as Lifetime Movie Network meets Hallmark Channel.
And this is getting me to think because, my husband and I do have wills and, we have done our estate planning, but it's not that detailed as far as, if I am unresponsive, then what? Of course, it says if something happens to me, then he is the next person. If something happens to the both of us, then we have decision makers. But as far as, getting that technical, we might need to go and do some review.
Yeah, I think the difficulty with planning is that we look at planning from a traditional sense. And for those who are in the autism community, that planning has to it has to morph into another zone because you're not just thinking about today and tomorrow and what happens when I pass away. You're now thinking about the long-term care needs of your child and who is going to handle the things that you kind of naturally fall into, right? Because your child has certain specific needs that another child may not have.
Yes. Yeah.
And so the planning piece is not just getting like the documents in place and making sure the agents are designated and the beneficiaries are listed. But now you want to have that game plan where it's like, what is that food item that my child absolutely will not eat?
Yep.
What are the little routines that my child goes into in the morning, in the afternoon, in the evening? What are some things that we can do to soothe my child if my child is upset or having a tantrum? So I feel like when I look at planning for my families who are on the spectrum, I start to ask questions that have nothing to do with the traditional, the documents and the agents.
Yeah.
I think that's key for those in this community.
Yes. And we do have something like that, things that, she is sensitive to sensory wise. We have the big document in there full of the doctors, therapists, who needs to be contacted. And that is a document we, review every year. And if it needs to be changed, then we do. So to that document, like you said, some of the things that we have to think about are just different when it comes to this aspect, and preparing for this. So what are some of the basics that we should know when it comes to estate planning?
So for the keys, I always say that there are two different realms of documents. You have the living documents, and then you have the documents that take effect after death. So I would start with some basics like having a power of attorney and a healthcare designation with a living will. That's going to cover while you're living if something happens to you and you're unable to do your typical day-to-day things. And then on the after death side, your will doesn't kick in until you pass away. So that's key. And then for many families, especially those who have children who are under 18, you may want to look into the option of having a living trust created, which upon your death now becomes irrevocable. It becomes something that's in place long-term for your children. So those are the two realms. And then I say there are two other things. It's looking at the beneficiary designations, which can be your best friend or your worst enemy, because if you list a minor child as a beneficiary on something like life insurance, well, now you're going to open up the door to the possible need for a guardianship if that child doesn't turn 18 before you pass away. And also thinking about the planning for your property, most folks don't know that, you can establish some things for your real property and have some documents in place so that if you do pass away untimely, right, that you have somebody already in line to receive, whether it be your trust through your trustee, or maybe some other individual like, an older, family member who can take over that home and make sure that your children have a place to stay. So, your property needs planning. You need to look at those beneficiary designations, living documents after death, and know that a will alone is not planning.
Mm. Yeah, when we were doing ours, and this is what I found funny, like you were saying, about the person who's designated over the money, because they were like, okay, well, if your children are underage, this is the person you want them to go to.
Right.
Who is going to, do you want that person to be over the money, or you want somebody else to be over the money? And then
Right.
I'm like, these are very detailed questions. It gets you to thinking, like, if I trust them with my child, do I trust them with the money to make sure it's going to be going to the child? So it's things that you do not make a decision at that time. It was something we had to actually have a detailed discussion about. And it was like, oh my gosh, I just rather not die at any time. This is really deep.
Yeah, it's a lot. There are a lot of little things that I don't think I ever really thought about, even as an attorney, that when it comes to different populations, there are a lot of different things that you may have to think about that, the average family may not have to consider or deal with. So, I think it's key to let families know that when it comes to estate planning, it's not just the will. Mm-hmm. And most people, that's their go-to. I just need a simple will. Well, there's no such thing as a simple will because our lives aren't simple.
Yes.
That just doesn't exist.
Yes. And like you said, one of the things that we need to think about is guardianship. So I want to talk about that for a moment. First, what is guardianship for those who don't know?
So for those who don't know, guardianship is a court process. And basically what that process does is identify an individual who will serve as the guardian for another individual who is unable to make medical or financial or otherwise just general well-being decisions for themselves. Mm-hmm. So I'll give you an example of something I had today. I just completed a guardianship for a family who has an adult child. Their child is about 26, I think, or 25. On the spectrum as well, and has a lot of needs in terms of their general well-being and inability to manage money. And so because this individual is an adult, according to the law, they're an adult. They can handle their affairs. You can't speak on their behalf. So a guardianship steps in because there is a concern that someone is unable to manage their affairs and they need someone to be appointed, almost like having a parent again. Right after 18.
Wow. So, this does impact a lot of our families, especially knowing where some of our children, fall on the spectrum.
Right.
This is something that is a reality for them. Is this process difficult to get guardianship over your child?
So I will say that it is not a simple 1, 2, 3. Mm-hmm. It can be a bit difficult. The family that I was working with today, we've been working through this process for at least 6 months, if not more.
Wow.
And part of the issue comes down to guardianship happens in 2 phases. So you have an incapacity determination that needs to be made, and then you have the actual guardianship. So I say it like this: if your child is an adult, your child's an adult. Mm-hmm. And so special needs doesn't have anything that comes into play that says, all right, mom can still make decisions. It doesn't work that way. So you need to get some documents in place from a court that says, I am authorized to now handle my adult child's affairs after 18. And so it's difficult because you're first having to make a determination that this person can't make decisions for themselves. Mm-hmm. And that's a high burden. Like, you have to determine that this person is unable to. Mm-hmm. And then the court will look at whether or not someone is fit to serve as the guardian. And one of the things that people don't realize is there are 3 physicians that are appointed here in Florida in order to make a determination of what you're able to and unable to do.
Oh, wow.
So, if you have a child, for example, and I hate the word high functioning, but I'll just use it because I hear it so much. But if you have a child that, is well versed, speaks for themselves, has a lot of things that they're capable of doing, can you imagine what it's like for someone to be doing an evaluation for them to say that they're unable to make decisions for themselves?
Mm-hmm.
When visibly and verbally, they may seem to have that ability.
Mm-hmm.
So it's challenging. And in addition to that, your child, an attorney is appointed to represent your child's interest. So you have like 2 layers of safeguards. You have a committee of people and an attorney saying, I'm fighting for this adult to maintain their rights if that's a possibility, right? So it can be challenging, but I will say that most of the cases that I've dealt with and most of the colleagues that I've dealt with in this realm have been successful in supporting families to get a guardianship in the event that they need one, especially when it comes to autism or other special needs.
Perfect. So when a parent is going through this guardianship phase, it has to be an actual physician that has been appointed or approved by the courts to make this decision. It can't be me going to my family physician.
Right. So in terms of the process, so I'll break it down like this. The incapacity part, you're petitioning the court to say, my child is unable to make medical, financial, general well-being decisions for themselves. Soon as that is filed, the court basically appoints a panel of individuals that are appointed by the court, and then they also appoint an attorney for your child. So immediately you have 3 individuals that will be evaluating your child at one point in time during a small window of time. And then you have an attorney that will also be communicating with your child, to obtain their perspective if possible. Once that process is completed, there's a court hearing that's held. And basically all of that is brought to the table, including the parent's perspective. And so the judge has to make an evaluation according to what the professionals recommend, what the attorney for the child says, and then I, as the attorney for the parents, I'm going to have arguments that I'm going to put on the table as well. So it's just a step-by-step kind of thing. There's a bunch of little pieces that come together. But once that determination is made, typically, I've found that the judges will sign the order for the guardianship at the same time because you're having to file everything pretty much at one time.
Okay. So let's say that the parent goes through the process, they get guardianship, and then, down the line, they die. Is it in the guardianship that they pass this on to somebody, or does somebody then have to go through the process again to have guardianship over the child?
So I've seen different instances of that. One has been that another family member or another, trusted individual in that child's family will step forward and basically complete similar paperwork, but not as lengthy as the initial process. So it's more so things like the fingerprints to do the background check, the credit reports, and then an application. Yeah. And I've found that process of appointing a successor guardian is a little bit more streamlined and straightforward than the original process. Also, I have seen in some instances where the court looks to establish a standby guardian or someone who would step in if the person, like if the parent passes away or if whoever the guardian is passes away. So those are some things that you could look into as well.
Perfect. Thank you for that. Now, moving on to trust, because I see a lot of this conversation happening in a lot of the parent groups that I'm in, and people not quite understanding what a special needs trust is, or there are different versions. So can you explain exactly what a special needs trust is?
So I'll talk about a special needs trust in terms of the document, and then I'll talk about it in terms of the concept.
Okay.
So in terms of the document, a special needs trust, I almost equate to a contract. And that contract basically says that this individual is establishing some property that will be utilized for their special needs. And this will not prevent this individual from obtaining government assistance. So in a short sense, I would say that the assets that you use to either fund or support a special needs trust are often things that will be used for special treatments, travel, respite care, alternative treatments, therapies, all kinds of things that you will have to supplement what your child needs outside of what government assistance may provide. Okay, so the document itself is something that comes in different forms. Oftentimes, parents will have a trust or a living trust, and within that trust, they will have a section that provides special needs provisions. And usually here in Florida, we talk about it as a supplemental needs trust. Mm-hmm. And basically, you have like the big master trust. And then within that trust, you have some subsections. And one of those sections may be a supplemental needs trust that says this particular child or these sets of children are protected by this trust, which basically has provisions that identify what those funds will be used for. And those will fall in line with what the rules and regulations are when it comes to government assistance. Okay. Mm-hmm. Now, the concept generally behind what's called a special needs trust or supplemental needs trust is the fact that you don't want a child to lose out on long-term care benefits just because, maybe the family has some assets that they put aside. Because when you have a child with special needs, that expense, it can be astronomical. So, it's not always enough to say, hey, I put some monies aside. Yeah, but they need care for possibly the rest of their lives. Yeah. So it allows them to get government assistance, like getting SSI benefits, sometimes getting certain, Medicaid, other treatments, maybe other funding, because that will cover their essential needs. And then you have the trust that will cover their supplemental needs.
Yes, I know that one of the questions are centered around the special needs trust in the groups that I was seeing is, if I do this trust, will they be able to still get Social Security? So thank you for, touching on that, because I know a lot of parents will then, if they think their child will not be able to qualify for SSI, right, they will not do the special needs trust.
Right. It just has to be done properly. So there's language that needs to be in there. So the best thing that they can do is seek out an attorney, work through the language of the documents, making sure that all things are covered, and then also working with their Social Security benefits to make sure, everything is in line. The Social Security benefits, they will tell you what, assets count, assets that don't count, and then your attorney who's handling your estate planning will make sure that the language that needs to be in place in the trust is there, so that if Social Security ever asks for it or if Medicaid ever asks for it, there's language in place that protects them.
Perfect. And when we're looking at a special needs trust, is there a bank account that's associated with it, or how does it normally work?
So the interesting part with trust, and that most people don't know, is you can fund a trust with different things. Examples, you can fund a trust with a bank account. That would be like a basic way to fund the trust. Mm-hmm. I've also seen folks fund a trust with a life insurance policy. I've seen them fund trusts with other investments and financial accounts. I've also seen trusts funded with real property. Because the property has value, you could easily sell a property at a certain point and get those monies, back into the trust to use those monies. And sometimes people want to have the property so that the child will have a place to live and maybe have some long-term caregivers. So there's more than one way to fund a trust. There's, all these accounts that I hear about, whether it be these ABLE accounts or other special accounts. So you have a variety of options. You're not just limited to one or two things.
Perfect. And then when we're talking about, the child receiving the trust, is there an age that can implement on it? Like if I don't want them to receive it at 18 and they can get it at 21, or do they have to wait till I die, or how does it work?
So I'll go back to my description of the trust as a contract. Mm-hmm. And basically, because you as the parent are creating this contract, you can outline it how you want. I don't know if people ever in these groups talk about the trust fund kids. One of the keys is you'll often hear people will speak of trust fund kids receiving funds over periods of time. Mm-hmm. Maybe every 5 years, or every year they receive a certain amount, or maybe they get a monthly allowance. So you as the parent can decide on how that is established, but you also have to be mindful of the concerns of providing too much distribution to impact their eligibility. So you have to be mindful of what those funds are used for. If you're paying it out to the child, you have to make sure you talk to your attorney and, speak to your folks at Medicaid or Social Security to ensure that you're staying within the eligibility requirements.
Yes. And that's a good point, because I know when me and my husband were doing ours, we just set up the age for all of our children to get it at 21. We weren't even thinking about impacting if Malia, down the line wanted or, qualified for, Social Security. So that's something we're probably going to have a conversation around, because we just, let it 21. But, like you said, if they're getting a large sum that could impact, that's something that you need to be mindful of.
And you created a thought in my head about the planning process. Mm-hmm. Estate planning is not a one-stop shop. And I'm glad that you're mentioning that you want to go back over some things with your husband and the paperwork, because people often think, all right, I prepared my will, I'm good. Mm-hmm. You have to prepare your documents to live according to your time. They are living, breathing things that should grow and change with you. So at all times, you should be trying to see, how can I make some tweaks? Just like every year you do your taxes and do other things, you want to also check your documents, check your beneficiary designations, verify certain things to make sure that they're still up to date.
Yes, good point. Yeah, like I said, we circle back yearly on ours just to make sure everything is up to date and, still relevant to, what we're experiencing. So yes, it is definitely something that you can always go back and change. Once you put a person in as a beneficiary, you can change them, because
yes,
I definitely have.
Absolutely.
Okay. So as we get to wrapping up here, because you've provided so much information, are there any resources for parents and caregivers that if they don't have the means to afford an attorney to be able to help them with their estate planning, what they can do? Is there a DIY method or low cost alternative? I'm not a DIY, but I don't know if that applies in this instance.
It's interesting, because on the one hand, I think in this day and age with the technology, people can do pretty much anything. There's so many different resources. I mean, if you Google search, you'll find out a lot of things. What I say to those who want to attempt a DIY method, please consider seeking the advice of an attorney anyway. Mm-hmm. Let's say you want to prepare your documents on your own. Maybe talk to an attorney to say, hey, would you mind reviewing my documents and giving me kind of some feedback? They don't have to give you legal advice, but they could say, well, this provision here, this is what this provision means. Mm-hmm. And this provision here, this is what this means. So, the low cost alternative to me is, if you're going to do the DIY, at least maybe consult with an attorney to assist in the review of your documents and make sure that what your intentions are actually legally sufficient. Mm. And the other thing I would say is, there are so many things that you can do to educate yourself and go out there to different events, because a lot of the different community groups will oftentimes have things where you can get a free will done, a free power of attorney or healthcare. I won't say so much for a trust, but you never know. I know I've worked with different clients over the years on different plans and configurations, and a lot of my colleagues do the same. So you'll find something out there if you're searching.
Perfect. Any advice to parents and caregivers going through this process?
So my advice would be patient, educate yourself early, and don't wait until, you need, for example, a guardianship or you need a power of attorney. Educate yourself now and do things as early as you possibly can. A simple thing you can do to start today is start writing your what if checklist. That would be the first thing you can do, and that's a great step forward.
I love that. Because like you said, when things happen, those are stressful situations, and yes. Trying to do this planning in a stressful situation, which in our community is more of a norm, because a lot of us don't even think about estate planning.
Right.
So we're doing a lot of things in the stressful moments of not only trying to plan, funerals and things like that, but also then having to pick up the pieces and think about this planning portion for the children that, are left behind. So, like Sandy was saying, make sure you're thinking about this now, rather than leaving it with, your family members to try to figure out, and they don't even know what your wishes were.
Absolutely.
So where can the listeners find you, to get some assistance? Because I know that as soon as this podcast is over, I'm going to be getting my assistance.
So I'm a social media head, so you can find my firm on Facebook at The Spectrum Law Firm or Spectrum Law Firm Miami, PLLC. You can find us on Instagram at Spectrum Law. And please note, you can also book appointments on our Facebook. So all you got to do is look us up, Spectrum Law Firm Miami, PLLC, and our number is 754-202-8778, or we also have a toll-free line, 888-959-8264.
Perfect. And do you see clients out of state or just for the state of Florida?
Interestingly enough, I do have a lot of out-of-state clients here and there, but they're usually probate and guardianship based. As far as estate planning, if they live here in Florida and they're just maybe traveling out of state, yes, I can see them virtually mostly right now.
Perfect. I just want to thank you for being on the podcast and dropping all these gems and helping us with, a very difficult conversation that you actually made very easy and easy to consume. So thank you for that.
Thank you so much. And I'll give you my freebie. So A free 15-minute consultation. All you have to do is use the code Autism in Black.
There you go. Use the code Autism in Black for a free 15-minute consultation. And all of this information will be in the show notes. So thank you, Sandy, for being on the podcast. And thank you all for listening. And we will see you on the next episode of the Autism in Black podcast.
Thank you.
If you haven't done so, make sure to subscribe to our podcast so you can always be notified when a new episode drops. To get the resources shared on today's podcast and the show notes, make sure to go to autisminblack.org/podcast. And be sure to share your takeaways from the show on IG Stories and Twitter using our official hashtag AIBpod so that we can find them and share them. And if you want to continue the conversation from today's episode, make sure to join our Autism in Black podcast Facebook community. And please make sure to answer the questions to gain entry. Thank you for listening and joining me this week. Have a good one.